All right, folks, welcome back. And all I want for now is just to do two more questions from chapter 19. And I will do two questions in different ways. The first question is not how you want to do it when you answer part B of the exam. Okay? The second question follows ILAC. So I just wanted to compare and contrast how these two questions are being answered. The first question. So page 541, question 3. Sue and Mike formed a company to acquire and develop certain land. The board of directors was made up of Sue, Mike, and two other people. Okay? The development of the land was left to Sue. So this is a company, board of directors, Sue is one of them. They left this function to Sue, who, with the knowledge of the board of directors, acted as a managing director. No problem yet. Here's the problem. She had never been formally appointed to the position. So this is the board of directors. One of them is doing the land development, so she's the managing director. Okay? But she was never appointed by the other two directors or by the board of directors as the managing director. Okay. Doing her job, Sue employed a company of architects to draw plans for the development of the land, but when they presented their bill for payment, the company refused to pay. So she's the managing director, she's developing the land. Okay, I'm gonna cut a contract to these architects to come and develop the land for us. Great. The time came for them to be paid, but the directors, the board of directors, the company refused. The company arguing that it had not authorized Sue to employ them. How strong is that argument? So your job is to advise this company of architects on whether they have a case that they can put forward as to why they should be paid and what that case is. So, any ideas before we start?
They are under the firm belief that they had a contract.
So this is the third party, right? So let's just first talk about the agency. Who's the agent?
Is there an agent?
Is there an agent? Is there an agent? Who's the agent in this case?
Sue.
Sue. Yes, everyone? Sue is the agent. Who's the principal? The company. So the company employs Sue. She's the employee. She's also the managing director, but she was never appointed as such. Okay? But she is their managing director. Yes? And the third party is the architect. Okay. So Sue entered into contract between whom and whom? Between the architects, the third party, and the company. Okay. Now they want to be paid. The company is saying, we don't have a contract with you. What do you think? So the second point after what Michael talked about in terms of finding whether there's a agent is to see whether the agent had any authority to do what they have done. What do you think? What is the issue in relation to authority here? Or what's the problem? She has not been appointed. So does that mean she does not have authority to enter into these contracts? You remember what we talked about in terms of authority?
Not necessarily.
One of them was express. There's an express authority. I gave you this, agreement or contract to say that you are the managing director. But there are other ways. Some of them are implied, and some of them are ostensible. Okay? Ostensible. So it's called apparent. Because you come to me and you say, I'm the managing director, and you call me and talk to me and meet with me and enter into this contract with me as the managing director of this company, would I, as a reasonable person, be justified in saying you have the authority? Even though you didn't. A reasonable person would think so. And that's enough. That's the legal test. It's an objective test. Remember, all of our discussion of contract was really about objective theory of contract. That's the main thrust today in relation to contracts. So here the board of directors allowed one of its directors, Sue, to act as a managing director without having been formally appointed. Thus, she will have apparent or ostensible authority to deal with third parties in a manner consistent with the functions and duties normally falling within the usual authority of the holder of such a position. Okay. So she employed a firm of architects to draw up plans for the development of the land. This is similar to a case called Freeman and Lockyer versus or v. Buckhurst Park Proprietors. And this is from England Reports, 1964, on which the facts of this question are based. The court held that the company was liable because the kind of contract which was entered into was within the usual authority of a managing director to enter into on behalf of the company. That's the key point, usual. It was a usual authority of a managing director. So they would be entitled to recover their fees. So far so good? This is the way I don't want you to answer the question in the exam. If this was an exam question, this is not how you want to do it. You know, write me some sort of an essay, because the markers are going to be confused. So you want to be technical. You have to be specific in what you're doing, and this is how you're going to do it. Let's look at another question, question 5. This is how we're going to use ILAC, and this is how you're going to do it in the exam. In just a minute, I will talk as well about the exam briefing. Estate agents wrote to a house owner, A, real estate agents, right, who was keen to sell his property, and he accepted an offer from him to become his agent. Okay? So the owner of the house accepted an offer from the estate agents to become his agent in order for them to sell the house. Okay? In the letter, they pointed out that if they were able to find a willing and able purchaser, they would be entitled to a commission. So this is the remuneration, you remember, one of their rights, at normal real estate institute rates. Okay? So the key point, I find you the buyer, you are going to pay me this commission, and we know the price, we know exactly the rates for these commissions. Okay. The agents then introduced the owner to B. So it's just like the wife. But here they found someone, B, who said she was prepared to buy subject to contract and subject to surveyor's report. What did we call such things when we talked about contracts generally? These are conditions precedent or subsequent? Are these conditions before we enter into the contract or after we enter into the contract? Before. So we said this is a precedent, a condition precedent, meaning what? The contract will not come to existence unless these conditions are met. Two of them, subject to contract, we have to sign. So probably there's legal advice and all of that, and subject to surveyor's report. Subsequently, A, the owner of the house, received a higher offer from another party. Okay? And accepted it. Okay? So you had this thing inked in relation to an agreement subject to contract and subject to surveyor's report. So the question is this legally binding? I.e., does a contract exist? We just said no. So A then went and found someone else on their own, and that person decided that they could pay more for this property, so they went ahead and had a valid contract. When the agents claimed their commission, so the agents now realized that the home has been sold, so they thought, well, it's now time for you to pay us. Okay? Stating that they had introduced a willing and able purchaser. A willing and able purchaser, but of course A refused to pay. Okay? The question is the owner correct in refusing to pay the agent's commission? What do you think?
Did the house owner receive the offer by themselves, or did the agent get that higher offer?
So, as we see here, it says A received the higher offer from another party and accepted it. How do you interpret this sentence? Are you going to interpret this as A received this higher offer through the agents? And if that's the case, would there be any legal issue? No. So if this is something you're writing in the exam, you should say something like, if we assume that this higher offer was received through the agents, then there would be non sequitur, i.e. you would have to pay them their agent's commission. But what we're talking about is not this offer really, we're talking about the offer that they got from B. They're saying, the agents, that we found you this willing and able purchaser. What do you think? Is that person willing and able purchaser? Someone says no.
She was prepared to buy, so she hadn't actually entered contract.
Okay. So, when does the commission become due? You have to pay after what? After the sale. So you have what? You have an existing contract and it's a valid contract, an enforceable contract. Is that the case here? No. That's the gist of the argument. That's what you want to put in words, but through ILAC. So the first thing you're going to do is whether A should pay the state agent's commission or a commission. The starting point is to see whether the real estate agent should pay a commission. So when I say should, it means that legally binding. They have to, based on the law. Now, remember one thing about the issue, it can come in different ways. So one of you might actually improve on this sentence and put it in different words. Okay, that's fine. The first thing I want to say is that when you write it in the exam, okay, you will have to have something like issue 1. Because there will be more than one issue in the question or questions you will get, and leave space underneath it, because you might come back and cross it out and decide that you write something completely different. So give yourself some flexibility. That's the first thing. But always remember, try to fit all of your ILAC on one A4. So in your exam booklet, one page is one ILAC. One page is one ILAC. So issue, then after the issue, you're going to write the law. The law is going to be much longer, of course. The issue is always one sentence, the conclusion, one sentence. But the law and the application is where most of the marks are. Where the agent is to find the purchaser or introduce a prospective purchaser, no commission is payable unless the person is ready and willing to purchase, is able to purchase, and in fact purchases by entering into a binding contract on those terms. You need a binding contract. That's the law. Where do you find the law? So one of you asked, what can I bring to the exam? I said you can bring a suitcase. You can bring anything that's printed. Anything in print, bring it. It could be your textbook, other textbooks, the slides on the study desk. You can bring in the tutorial questions and answers. You can bring the old exams and your answer to the multiple choices on those old exams. You can do anything you want. So the law is going to come from you. You have your notes, you have something, you whatever. Remember, it's only going to be an hour and a half for the questions in part B. So you should have something, I believe, economic and efficient. So maybe something like 10, 20, maximum 30 pages. So you have to do your own work and do some notes. I'm giving you some notes, but I think you should improve on that. That's where this is going to come from. I don't care if you even just copy from that. The key point, of course, you're copying what's relevant. If you're just copying and you're going over and you have 2-3 pages copying the law, time is over. Now remember, it's not going to be only one issue. If you identify one issue, you're going to fail part B of the exam. There's many issues, so you have to be structured and go through it efficiently.
When we put the law in, do we have
Yes.
to specify where that comes from?
Sometimes.
From a case?
Sometimes. Some stuff you have to actually explain where that comes from. For example, continuing with law, the rule that any terms in the contract will be required to be performed exactly is fairly strictly interpreted at common law, as can be seen from the decision in Remoor, which is one of the cases in your textbook. The entitlement to commission arises, that's the key point we were talking about, upon the agent introducing a person who buys. And this is the event on which the entitlement to commission arises. The transaction, the contract has to be discharged. The sale has to happen, then you can ask for commission. Continuing. If the person introduces it, if the person introduced is to be willing and able to purchase, they must be able to do so in every way. So they give you this case, which is in the tutorial answer, but it's not in your textbook. So it says, this case, Graham and Scott, Southgate, and Oxlade, on which the facts of this question are based, the court held a person is not willing and able if they enter into a contract subject to contract and subject to surveyor's report. So when someone says something like that, you know that they are not actually willing to enter into the contract. They are not willing and able, meaning that you don't actually have an offer that could be accepted still, which means that there's no sale, there's no contract, no commission. Okay, so application. All of this should be on one page. The agent has not introduced the ultimate purchaser. Of course, the law, you can see I put a lot of the law. I put a lot. You could just probably settle for part of that, even the part that I've highlighted, underlined. Now, you might skip mentioning any cases. So how is that going to affect your final mark for this part? Maybe you will lose 1 mark. That's it, because what we're interested in is how you're going to apply. So it's never going to be really how much you know about the law, for the simple reason that this is an introduction to law course. It's just an introduction. So I don't want to see how deep you understand the law. I just want to see whatever you know about the law, how can you apply it? And then that's the skill you take with you. So the agent has not introduced the ultimate purchaser, but a prospective purchaser who may or may not have subsequently gone ahead with the transaction, and by making the contract subject to 2 conditions, the prospective purchaser demonstrates the unwillingness to enter into an agreement that would have entitled the agent to their commission. All right, so with that we come to the end of the tutorial. Yes?
Could you say in there if the agent proved that they had given that they introduced that person?
B?
Yeah, if they introduced B to A, like down the track, we did actually let them know that that place was for sale. Could you say then that then there would be a commission? Or would that be?
So again, the trigger event for the commission is that the buying and selling, the transaction occurs.
Yeah.
So until that contract is consummated, until that contract is discharged, there is no commission.
No, what I'm saying is the person that eventually bought the place.
So the one we were disputing whether the agent introduced to them or not.
If the agent could show that they did actually introduce them, then could you say that in, like, if you say that in there, are you going to get more or less marks? Or?
Absolutely. No, that's perfect. That's great, because that's the critical thinking we want. Someone is saying, Michael is saying, if I say, for example, that maybe this other person who ended up purchasing the house knew about the house from B. And B, of course, knew about the house from the agents. So somehow the agents were part of this introduction or transaction, even though not directly. That's a great argument to raise. Of course, not necessarily because that's going to tip the answer to one side or the other, but at least it shows us that you understand that if that's something I could go after, then I can change the answer.
Then I could make it. Then you could make
Turns. There would be commission. Yes. All right. Okay. So let's stop our recording another time, and one more thing for today, and then we'll be gone.